Hello and welcome to Chetan Bharat Learning. Today we're going to do current affairs for polity from 27th of November to 3rd of December. Alright, some of the most important developments in polity took place in this week, and I need you to be excessively careful today because a lot of these questions that were pondered upon by the intelligentsia across newspapers can feature in your GS questions. Alright, so what are we going to today cover? The first and foremost is going to be the Election Commission's new proposal to Union Ministry for Law, where Election Commission stated that they're now administratively and technically ready to extend voting procedures to non-resident Indians. All right, we're going to understand the stakes involved in such an exercise and why Election Commission feels it's ready. All right, then we're going to talk about the All India Presiding Officers Conference. A couple of things happened there. First, what happened was that the Vice President of India flagged judicial overreach. All right, the Vice President of India said that maybe the organs of our government structures should refrain from encroaching upon each other's jurisdictions. And the second thing that happened there was that the Prime Minister also said maybe it's time for one nation, one election to take shape. All right, so we're going to take control of these three topics and come up with answers to write in our GS questions. All right, then the center has recently said that they are committed to amending the sixth schedule. We're going to try and understand what sixth schedule is, what are the shortcomings that need rectification, and why is there such a push for amendment of the sixth schedule. All right, now there's a spate of laws coming across from different states that have marriage and conversion in the same sentences, right? Sometimes we don't quite understand what's happening, what's the law, what does it say, and what does it imply. We're going to try and understand that, and then we're going to do two topics that turned up in this week for prelims. All right, what is Pragati portal and what is Nyaya Bandhu app? All right, so let's dig in right away. Let's start with the Election Commission and postal ballots. All right, so right now the structure for electoral voting that we have pretty much divides the electors into three categories. There are some general electors, right? Like us. We live in India, we live within our constituencies, and the polling station is never more than 2 kilometers away from us. All right. So that allows us to exercise our right to vote more efficiently, more frequently, and have our voices heard by the governing structures. All right. So the next category of voters that we have are called service voters, right? So if you're serving in the army and you're from, let's say, Chandigarh, and you're serving in Jammu and Kashmir, just because you're serving your country does not mean that you are devoid of your right to vote. All right. That is why there is a category of service voters, and there is an entire procedure associated with how service voters can vote and how they do not vote. The third category of voters is obviously overseas voters or non-resident Indians. All right. So what is the procedure right now? How do they vote? All right. So we're going to understand all of these three things. So what happened was that the Election Commission told Law Ministry that they are ready administratively and technically for extending postal voting procedures to non-resident Indians. All right, and this comes in the wake of the impending assembly elections in Assam, West Bengal, Kerala, Tamil Nadu, and Puducherry next year. Now, why are NRIs important? You'd realize there are more than 1.26 crore NRIs currently overseas, and about 60 to 70% of them, which is a fair estimate, could qualify as voters who are also registered on the electoral rolls of the assembly from where they are, right? So right now what happens is that if they want to exercise their right to vote, they have to come all the way from these foreign countries, take a flight or a ship, land here, and then vote, right? Which is a little excessive, right? The demand upon them to exercise their right is a little excessive. Now I'm going to tell you the tale of an election is in Moldova, right? So Moldova is a country of whom a huge chunk of population is actually outside the country. But their electoral laws specify that those people who are not in the country and are currently outside the country can also vote. So the entire election pretty much hinged on the opinion of people living outside, right? So we could also have a system like that if people living outside the country get a say in our electoral system, especially in Punjab, Kerala, and some other states. In, for example, Telangana, there are assembly constituencies which could swing just by virtue of their vote. All right. So it's important constitutionally that they get a right to vote, and it's important politically, right? Our electoral politics could hinge on this development. All right. So let's begin, right? So what is the process now? The process, as I told you, is that they have to come to the constituencies and then they have to vote, all right? But as I told you, the NRIs have been sending many representations to the Election Commission saying it's not feasible. Sir, we can't really travel all the way from Australia or Canada or to Punjab or other states just to vote. And it's an important right. If you say the residents in India do not have to go more than 2 kilometers to vote, why are we traveling thousands of kilometers to vote? The problem is so exasperated that up till now, unofficial data says, all right, it says 10,000 to 12,000 people have cast their votes this way only. That's the only number, right? 10,000 to 12,000. And imagine the total scope of this electorate, right? There are 1.26 crore people, out of which 70% are eligible, all right? So you can see the problem. Now, this proposal that has come to the law ministry hinges on this electronically transmitted postal ballot system, ETPBS, all right? It's not that ETPBS is not in use, it's already in use. Now they're talking of extending ETPBS to NRI voters, right? How does this work? This works this way, all right? So it's already eligible, it's already in function for service voters and overseas voters who are part of the diplomatic missions. So what happens is, these guys, the RO officer here, the returning officer in our constituency, sends them an email, and on that email, people, the service voters, they open their email and they download the copy and then they print it, and that's a postal ballot on which they choose their preferred candidate and send that back through post, all right? So that's the ETPBS system. Now, what they're saying, what the Election Commission, what their proposal says is that they are going to amend something called the Conduct of Election Rules 1961 and extend ETPBS to overseas electors, all right? The rules were amended in October 2016 to extend this facility to service voters, right? And now there is a proposal to amend these rules to extend this facility to overseas voters, all right? Now, this is where you need to stop and absorb what they are saying, all right? So what are they saying? They are saying that the 1951 Representation of People's Act, Section 6, has already provided with anyone who is on the voter roll with the right to vote. So anyone who is already on the electoral roll, irrespective of whether he is in India or overseas or serving his country in uniform, already has been provided the right to vote by Parliament way back in 1951. So now the Election Commission in this proposal is only extending that right through an executive order. For example, these rules is only extending that right to overseas voters, all right? But some people are saying, all right, some constitutional experts are saying that this is a big change in our parliamentary democracy. All right, Constitution says the parliament should decide. The executive is saying the parliament has already decided in 1951, but constitutional experts are saying the parliament needs to take this call. If overseas voters can easily vote or not, if they are supposed to vote by turning up in India or they're supposed to vote staying there, is a call that the legislature should take. All right. In fact, there was a bill that was going on, like that had been introduced in the lower house of parliament in 2016, that did not talk about ETPBS, that said that the overseas voters could vote through proxy. All right. So, for example, if you're living in Canada and you're registered on the electoral roll of, let's say, Zirakpur constituency, then you could appoint a proxy. You can tell your family member that you have to vote on my behalf. All right. So the 2017 legislation tried to do this through proxy voting. However, it passed the Lok Sabha but did not gain a consensus in the Rajya Sabha, and the bill lapsed in 2019. So that route which went through the legislature, which went through the parliament, might have had more constitutional authority, right? Because the current route through which the executive is trying to do this does not involve a parliamentary nod. All right. So now I hope you understand the two arguments. One argument is that it should go through the legislature, as was the plan from 2017 to 2019. And if the Rajya Sabha didn't agree, then convince Rajya Sabha. All right, that's the way. And the executive argument is that the parliament in 1951, through the Representation of People's Act, Section 6, has already given given everyone on the electoral roll the right to vote, and we are, through these conduct of election rules, only extending that right to the last person who wants to vote. All right. Now, I hope you have understood the two parallels of arguments that are running in this. All right. So now there are three broad concerns, and whatever question turns up in the exam, your answer would have to pivot on three broad concerns. All right. This is how you would end your answer. All right. So first big concern is, as I told you, is that such a big decision cannot go through without Parliament's nod. All right, this is the biggest concern that they have, and then the Parliament's nod is important for such a big step. All right, now the second concern is more of an opportunity cost based argument. All right, so what are they saying? They're saying that, have you thought about migrants? There are so many people who are from one state registered, let's say for example, in the electoral roll of a constituency in Uttar Pradesh, but currently working in Gujarat. Have you provided a mechanism like this for them? Not yet, right? There are more than 10 crore people within our country who qualify for voting but could not vote because they are, for example, in Tamil Nadu and their home state is, let's say, Haryana, right? So do something for them first, right? Make the right to vote more feasible, more accessible for them. For example, what they're saying is, if there are Punjab Legislative Assembly elections happening, and if there is some person from Punjab who's currently in Odisha, who is not a service voter, ensure that he gets to vote. All right, so that's the argument right now. The third argument is a more recent one. All right, this comes from Sitaram Yechuri, who's a big politician from the Communist Party of India. He said most of the migrants, or many migrants who actually go from southern areas of India, go to Gulf countries, right? West Asia. And those regimes are by themselves autocratic in nature, right? You must have heard reports of how people's passports are impounded in Saudi Arabia. They are paid lower wages than the government prescribed rates. They are often held captive. Now, if a lot of these employers of Indian people get together and decide that they are going to disenfranchise Indians, or that they are going to make these migrants vote a certain way, then we could have election rigging in a foreign country, right? We could have election rigging in a foreign country. The fourth argument, which is not here, that you don't really need to think about, which I thought I should just tell you, all right? The argument is that the Election Commission itself is not very sure, right? The procedure that has been prescribed is not certain. So for example, it's not sure whether these people outside the country are going to simply send their postal ballots to the returning officer or in India, or are they required to send those postal ballots to the embassy, and then the embassy will sort of sort these ballots according to constituency and then send these ballots. Now, these are not substantive arguments, clearly, and the Election Commission can say that we have thought of this. This is not the primary concern right now. But some people say that if you're coming up with such a big step, at least get the exact procedure right. Don't push through such important steps without a clearly defined procedure for how it is to be done. Now, I hope if there is a question that turns up on postal ballots, you are going to be able to write a good answer on this. All right, so the next topic that we're trying to cover is the vice presidential comment on judicial overreach. Actually, it's a little more complicated than that. What did the president say? The president was addressing the 80th All India Presiding Officers Conference, and the first session of the conference itself, right? The first session of the conference itself had this lecture by the vice president, this address by the vice president, where he said the judicial overreach is a literal problem now and we need to deal with it. Now, what did he highlight? What did he offer as example? He said that the judiciary has denied the executive a role in judicial appointments. All right, even though the constitution says that the president shall appoint, but judiciary through the NJAC, the NJAC judgment, has denied a role to the judiciary. And one very substantive example, and the other a little bit more procedural example, where the president alluded to the fact that Diwali cracker ban was not your domain. That the executive should have decided whether the crackers should be banned or not, or for any region or for the entire country. Just judiciary did not have a role to play there. All right. Right. So he said, and I really want you to focus here. I want you to write this in the answer. He said this is an avoidable blurring of the contours demarcated by the constitution, and this part, avoidable, यानी कि avoid किया जा सकता है, right? It could be avoided, avoidable blurring of the contours demarcated by the constitution, and this is where your answer is going to play out, all right? So you must know if there is separation of powers in the constitution or not, and whatever answer you write, it is going to come out of that only. Now we here are going to deal with this topic in detail, all right? So be prepared, focus, all right? Focus on the next part, all right? So there are two broad arguments for separation of powers, all right? The first is something called functional specialization, and the second is called avoiding concentration of power. All right, what is functional specialization? The argument comes from the fact that if there is one body doing a particular function, if the one body doing a particular function, for example, the judiciary, then it specializes in that domain by repeatedly doing it. All right, so it should only continue to specialize in that domain. All right, so there is functional specialization. For example, think of a body like the NGT, right, National Green Tribunal. Now if it suddenly starts entertaining cases with respect to campaign finance, it's not in its speciality, so it should continue to stick to the job that it does best, which is environmental issues. All right, so this first argument for separation of powers, for separating the domains of executive, judiciary and legislature, is that each wing should specialize in its own domain. The second argument for separation of powers is that in any system of governance, it should be avoided. The case scenario that should be avoided is that all the power is concentrated in few hands. All right, now we had despotic rulers, right? We have one king who is the ruler, who is the executive. He is also deciding cases, he is the judiciary, and he is also legislating, he is also the legislature. And in those systems, historical evidence shows that it always deteriorates into some sort of an anarchical system where corruption prevails and the systems of governance continue to deteriorate over time, right? We've seen this with Mughals, we've seen this with multiple forms of government in the past. All right, so these two arguments I really hope you write. All right, so based on these two arguments, we've seen two models of separation of powers. All right, so first model, which comes from, so for example, the US model, right? People who drafted the US model for separation of powers had actively read and understood Montesquieu's The Spirit of Laws. There's a book written by Montesquieu, who's a big French thinker, all right? He's written this book, The Spirit of Laws, in which he argues for separation of powers. He argues for a strict separation of powers, and the virtue of his argument is that there would be no concentration of power in a few hands. The sovereignty of the state shall be distributed within 3 organs. So there is no concentration of power, right? So we have strict separation. How strict is the separation in the United States? It's strict to the extent that the first 3 articles of the Constitution demarcate, not only say there is going to be an executive, there is going to be a legislature, there is going to be judiciary, they demarcate the provinces for these 3 organs of government also, right? Then we have the British model, from which we derive our function or our governance structure. Here, the best dictum or the best maxim sort of explaining the British system is that the British cabinet is the buckle that fastens the legislature and the executive, all right? So in British system also we have a judiciary, we have an executive, right? We have an executive headed by the Prime Minister, and we have a House of Commons or a House of Lords, so we have the legislature. Now, if there are elections, the people who win elections in the legislature, the commanding party in the House of Commons, what do? The House of Commons chooses few people among them to head the executive, right? So the cabinet, the people chosen to head the executive, come from the House of Commons, and that sort of fastens the buckle, that buckles up these 2 organs, right? The legislature and the executive, right? So if you've been following international media, you would notice that in the United States, every year what happens is that there is some sort of a lockdown, right? What happens is that the Congress, which has been given the powers of passing the budget, is not able to meet, or is not able to agree with the president, the executive. So the legislature falls in disagreement with the executive as to what money to spend where, right? And there are these long lockdowns for a month, or the government is shut down, people go without salaries. How much time does the British system or our system takes? 1 day to pass the entire budget, right? Then there is a process. For example, there is a 2-month long process, but it doesn't really take, the initial vote happens within 1 day. right? So why does that happen? Why is this ease of governance? Because the cabinet system is sort of a glue that holds the legislature and the executive together. All right. Now let's come to the Indian model. All right. So first thing that you should understand about the Indian model is that our constitution makers, our founding fathers, did not start with separation of powers. They said, let's design a good system. Right? They said, let's see what the good system is, and let's leave it to jurists to decide whether there is separation of powers or not. Let's not have separation of powers in our head and then go and decide and design the constitution. Right? That's an important point. Now, what are the implications for this? The implications for this is that there is functional overlap between the three organs of our government. And this term I want you to use again and again in your answer. What is it? There is a functional overlap, which means there is no functional specialization. What does this imply? This implies that judiciary has some executive functions, executive has some judicial functions, and the legislature has some functions which sort of infringe upon the domains of the other two organs. All right. So there is no functional specialization. Instead, what we have is functional overlap. And please write this down in your notes on the margins and memorize this. All right. It is because of this functional overlap. We are going to demonstrate the functional overlap also. We are going to see how there is a functional overlap. But it was because of this functional overlap that one of the biggest constitutional authorities of India, H.M. Sirvai, declared so much dramatically that I may at once say that our constitution is not based on the separation of powers. He said so in those many words. There is no separation of powers in the constitution. All right. So we are going to see whether this is right. Then if there is no separation of powers, then what is the Honorable Vice President talking about? And what has the judiciary to say whether there is a separation of powers or not? All right. So let's first demonstrate functional overlap. All right. Let's first see how there is a functional overlap. For example, judiciary, right? The constitution itself gives judiciary the power of judicial review under Article 32 for the Supreme Court and 226 for the High Courts, right? So whatever the executive or the legislature does, the judiciary has the power to tell the executive or the legislature that this is not done. This is not constitutional, right? Remember the NJAC judgment, the National Judicial Appointments Commission? What did the Supreme Court say? The Supreme Court said this is unconstitutional. How powerful, right? How powerful an institution do you have to be to simply brush aside the dictates of the legislature or the executive? All right. So we know that Supreme Court is powerful through constitutional prerogative only, and then it has extended this power of constitutional review to other domains, right? For example, in 1984, the Parliament said, henceforth, from now on, there is going to be a Schedule 10 in the Constitution, and legislators could be disqualified if they try and change parties too often and risk the stability of government. And the power to decide whether a legislator is disqualified or not is beyond judicial review, and the Speaker shall decide. And they put that clause in the Constitution, all right? It's part of the Constitution. In Kyoto Holohan, Supreme Court said, no, judicial review applicable. Think of the power of the Supreme Court. Supreme Court said, no, legislature is wrong. This judicial review is an intrinsic part of is basic structure of the Constitution. You cannot avoid judicial review like this, all right? Courts have routinely turned out, like set aside laws based on the lack of jurisdiction. Right? It says central government doesn't have jurisdiction, state government doesn't have jurisdiction. All right? The legislature's privileges have been cut out, have been thrown away by the Supreme Court, saying that this is not constitutionally valid. All right. And then you have the basic structure doctrine. The crowning argument of judiciary's encroachment upon other wings is the basic structure doctrine in Keshwananda Bharati. Right? What did the Supreme Court say? The Supreme Court said no law that you pass can infringe what? The basic structure. What is the basic structure? We will tell you. Right? Powerful institution. All right. Then in Vaman Rao and I.R. Kohilo, what the Parliament did was it said, okay, let's have a schedule. Let's have a schedule in the Constitution, the 9th schedule, and whatever laws we say are in the 9th schedule, please don't subject them to judicial review. Supreme Court said, nahin, that's not done. We can tell you if it's unconstitutional or not, judicial review applies. All right. Then Menaka Gandhi, 1980, what did the Supreme Court say? We can declare a law unconstitutional just because we think the process is not proper. All right. What did the Constitution say? The Constitution said judicial review can be applicable if the law is not passed by the proper procedure, right? If the parliament has not passed the law by proper procedure, the Supreme Court read due process into the Constitution. Not only should be a law passed by parliament properly, right? It should also be a law which is intrinsically logical and rational, and we shall decide if it's logical or rational, right? So these are some examples. All right, these are some examples of our judiciary flexing muscles. You can write others, right? For example, the Constitution itself gives this judiciary the power of Article 42. Article 42 says if the judiciary wants to do complete justice, it can do some certain things, right? And the Supreme Court has really exhausted its power under Article 142, right? And then judiciary has sometimes created bodies to oversee the executive. Right? It has sometimes, for example, in the BCCI case, right, it has created committees to oversee executive bodies, right? It has made legislators disclose their assets in the ADR case, right? It has made legislatures tell the population as to how much assets they have, what is their educational qualification, and what do they do for a living, right? Think of the power, right? Compare it to other constitutions and just absorb the power of judiciary in this case, right? And then similarly, legislature has some judicial capacity in the Constitution, for example, during the impeachment of the president, right? And similarly, executive has certain control over the judiciary. Now, I've mentioned many points in your notes, right? And you will go through them and you will understand them. I will highlight a few, all right? For example, it's very important, the lower judiciary, right? The district level judiciary, the conditions of service for the district level judiciary, for example, how much salary will they get, where they will live, what will be their service conditions of different type pensions and emoluments and everything is decided by the executive. So executive gets the power there. Right. So, for example, as I'm trying to demonstrate, judiciary has powers over the legislature and the executive. The executive, through, for example, control over appointments and service conditions of the judiciary, of the district judiciary, the executive can also prosecute judges under the Prevention of Corruption Act. Right. The executive decides whether an MP is qualified or disqualified. Right? You saw in the Delhi election, the Delhi Assembly case, the president on the advice of the Election Commission disqualified so many MLAs, right? By this logic, the executive can sort of render an assembly dysfunctional, right? So, executive has the power of pardon, right? Which is a judicial function. Right? Although the judiciary has said that judicial review is applicable there also, but think of the functional overlap within the Constitution. The executive staffs the tribunals that are created under Article 323A and 323B. Right? So the executive performs quasi-judicial functions of holding inquiries against their own members or other members. Right? So the Constitution itself has left so much room for functional overlap. It is only natural. That's the point I'm trying to come to. It is only natural that functional overlap will happen, and judiciary or parliament every now and then will find it within their powers to encroach upon the functional domains of other organs. All right. Similarly, I have given you multiple examples of executive overreach, right? You just have to skim through them. I've sort of explained to you the soul of the argument here. The MP Singh, right? MP Singh is a constitutional authority who has also said that parliamentary supremacy, on which the foundation of this constitution is based, is a myth. Right? H.M. Sirvai said there is no separation of powers. MP Singh says there is no parliamentary supremacy. In fact, sometimes people say the parliament is the weakest institution when compared to judiciary and the executive. All right. So there is this important part that executive is the most powerful organ. When you'll go through the points that are mentioned here for executive, you'll soon realize that executive is the most powerful organ in the constitutional scheme, and the judiciary, through its verdicts, has made itself equally, if not more powerful than the executive in certain instances, and both these institutions gaining power has come at the cost of the legislature. All right, the parliament is not as powerful, right? So, for example, in the electronic voting, the postal ballot case, what did I tell you? Like, do you remember we talked about how the executive, through amending the rules, is going to extend franchise, or is going to extend the ease of voting to NRIs, right? Ideally, that was the parliament's decision, right? But the decision will be taken by executives. The parliament is not able to sort of project its power. All right, that is another example that you can quote. All right, then here, as I've told you, judicial powers of the executive. Now I hope the functional overlap is apparent to you. You can illustrate it in your answer. Don't use more than 2 paragraphs for this illustration, not more than 1 if it's a 10 marker. All right, the last one, the crowning part of this question is going to be Article 50. How do you know? How do you know that the constitution makers were very aware of the fact that there is no separation of powers? Because of Article 50. Right? It's a directive principle of state policy, where the constitution itself says that the executives shall strive to separate the judiciary from the executive. The executive itself has to strive to separate the judiciary from the executive. Article 50 says so much, right? So what you're going to say is that you're going to use the judgment in Ram Javaya Kapoor in state of Punjab, where the Supreme Court said, and this is the conclusion of your answer that I want you to get to, all right? The Supreme Court said that the Indian Constitution does not recognize the doctrine of separation of powers in its absolute rigidity. It's not like the US. There's no rigid separation of powers, but the functions of different parts or branches of the government have been sufficiently differentiated. That's what you need to write. The functions of different branches of government have been sufficiently differentiated. So there is some sort of functional specialization also, all right? Although you can use the other cases also, but Ram Javaya Kapoor versus state of Punjab, if you can write this, I can assure you, you'll get more marks than your peers in this question, all right? Then another conclusion, if you want to argue on a different plane, right? If you think like your answer needs to be a little better than the others, there is an argument being made nowadays that the problem is just not judicial overreach, but also underreach. Right? How can both these things go together, right? It's a question of domain. There is a judicial overreach in the executive domain, but when it comes to exercising power under the habeas corpus writ, right, enforcing rights, the Supreme Court has sort of been shedding its responsibility, all right? And don't use derogatory language in this answer. Be very respectful when you write the answer. The Honorable Supreme Court probably has not been as active in terms of enforcing the habeas corpus writ, and say that commentators have said that. You don't need to name the commentators. The commentators have been saying this for a very long time, that probably where there is scope for judicial overreach is habeas corpus or enforcing other sorts of right, and not overreaching into the executive's domain. All right, I hope that's very, very clear to you. I really hope you write a beautiful answer on separation of powers if that question comes your way. All right, then in the same conference where the vice president made a remark with respect to judicial overreach, in the same conference the prime minister said it's time for one nation, one election. We've been talking about it for a very long time. Now it's time to implement this idea. If you get a question on one nation, one election, the first thing that you're required to demonstrate is that it's not a new idea. All right, that will tell the examiner that you're aware of the issue, that you tracked this issue. All right, in 1983 itself, the election commission said it's time to have simultaneous elections, state and central elections and state elections of all states to be conducted at the same time. Law Commission in 1999 sort of affirmed this idea and came out with a report saying this is what we will need to do, this is what these constitutional amendments are required. And after Prime Minister floated the idea in 2016, Niti Aayog came out with a working paper in January 2017. Now, it's an old idea, but what you also need to establish in one sentence or two is that we had one nation, one elections up till 1967. Right? Then what happened in 1967, or from 1967 onwards, some state assemblies started dissolving prematurely on account of imposition of president's rule or no confidence motions going through. Right? The state assemblies started dissolving prematurely. And what happened after that was that some assembly elections started happening at a later date, and some other assembly elections started happening at an earlier date, and the national elections happened on their own time schedule. All right, so the sort of scheduling of elections became an issue. All right, but you need to establish that we had simultaneous elections up till 1967, because if you establish that, then you sort of know that it's not that far feasible an idea. Right? If you establish that, then it's not a radically different idea, right? And then you sort of need to know that Election Commission, Law Commission, and the Chief Executive right now, the Prime Minister, the real executive, are all on the same page with respect to one nation, one election. All right, the Law Commission, the Election Commission, and the Prime Minister, right? So we need to know what is needed. Right? Now, technically what is needed is simple. You need to dissolve some assemblies ahead of time so as to have those elections aligned with the parliamentary elections, right? But then you have certain articles in the constitution that directly say that the tenure for legislative assemblies and the parliament is 5 years. So you would need a constitutional amendment, right? So this thing, most legislators, most experts say cannot happen without what? Without a constitutional amendment, right? And the Law Commission in its paper and the Niti Aayog in its paper have highlighted what changes would need to be made. You don't need to write those changes, because what is expected of you is to offer a substantive argument, not deeply go into the procedure. However, if you mention Article 83 and the corresponding article for State Assembly, we will come to that, then your answer does have an edge. All right. Now, if you've established these 3 points, first, that it's not a new idea. Second, we had simultaneous elections all the way till 1967, and the fact that a constitutional amendment is required for implementing such a scene, then you need to start getting into the substantive arguments for, arguments against. That is what you're required to do. You're required to be very observant and say these are the positives, these are negatives. So what are the arguments for? The most important argument for one nation, one election is that there is something called a model code of conduct. Now, what is a model code of conduct? Now, from the day elections in any state, local elections or national elections are allowed, there is a period of 2 months to 50 days where some things can be done and some things cannot be done by parties or governments, right? So what happened in the late 1950s and early 1960s, all the parties in Kerala sort of came together and said, henceforth, we are not going to attack each other personally. We are not going to appeal on caste and religion, right? And this sort of became a consensus in Kerala elections, right? That people would not cross certain boundaries when it came to elections, right? Then in 1989, T.N. Seshan, who was the chief election commissioner at the time, picked up this model code of conduct and really exhausted the power that came with it, right? He sort of enforced, because he said if Congress party was contesting an election in Kerala, Congress party can contest an election in other states and nationally also. So if your Kerala wing did that, your central wing can also do that. So he forced this model code of conduct on all the parties, and now there are some certain do's and don'ts for political parties and leaders that they have to adhere to. All right. Now, as part of this model code of conduct, what happens is that governments, the party in power, is not allowed to pass populist measures or any measures for that matter right before the election within the domain or the time period of the model code of conduct, right? For example, what is the concern? The concern here is that they would start saying that, okay, all the bridges shall be built at this time when elections are happening, so that people think, what a powerful leader, right? Or aid, right? Or loan moratoriums would be provided, or waivers would be provided. There are populist urges that need to be curtailed. Although this happens anyway, but this happens before the announcement of the election, but the Election Commission doesn't want it to happen right before the elections. Now, the Prime Minister said in his speech that this MCC disruption comes in the way of development. Right? There are elections happening all the time, right? Every 2.5 years, there's an election somewhere, either national or state. So this disrupts the pace of development, right? So if you must have noticed, right, every time you right before an election, you go to the DC office or any government office and you want something done, what would the official say? The official would say, now there is model code of conduct, we can't really do anything, right? Achar Sanhita lag gayi hai, we can't really do anything, right? So the Prime Minister said, that's a big hurdle. Then it would reduce the cost for conducting elections and for campaigning, right? So the Prime Minister said the Election Commission would not be required to be on their toes, spending money all the time, right? And the campaigning costs for political parties would come down. All right, this is another argument, right? Then the Prime Minister said this would ensure stability of government. We will come to this argument, right, later on. For now, just know that the Prime Minister made a point as to the stability of government. Then he said in local elections or all elections would be conducted with a very national perspective. Right, this is a argument for as well as against. All right, so it would be conducted in a national perspective. So a party contesting elections in Tamil Nadu would also have some sort of a position on national elections going on at that time, right? So, and that party would not have to spend money on state elections differently, separately, and national elections separately. All right, so there are multiple arguments here that you can sort of look at. One other argument is that the arguments for is that it would strengthen federalism, right? How would it strengthen federalism? They say because the state elections would be brought on par with the national elections. Now it's a flimsy argument, but it's an argument that could be made. All right, now what are the arguments against this, right? So first, people say there is no guarantee that the expenditure of political parties will reduce. Right, you can make an argument for the election expenditure of election campaign coming down, but I'm not sure the political party's expenditure would reduce. Right, it would also sort of reduce the importance of state elections, contrary to what the arguments for say. Like they say, the importance of national elections would come down. Right. Then they say it violates Article 83 Clause 2 and Article 172 of the Constitution, which is 5-year tenure for Lok Sabha and state assemblies, and that's why you need a constitutional amendment, right? And then the political argument against this is that is something based on electoral theory, right? What does the electoral theory say? It says that whenever a person is forced to make a choice with respect to national elections and state elections at the same time, the chances of him voting for the same party in national and state elections are higher, right? It's a theory, right? It has been tested, but up till now we see that it's not sort of worked out, right? So let's take 3 examples, right? The Delhi and Haryana elections take place very close to the national elections, right? Haryana, people did choose the same party in the state and in the center, right? But in Delhi, within a span of 6 months, people chose one party for the state and another party for national elections. In Odisha, where the state election and national elections took place at the same time, the people decided for someone else for as chief minister and someone completely different for the Prime Minister. In Bengal, right, when national elections and state elections took place in Bengal, let's leave Bengal for now, but let's focus on these 3 examples, right? So it's possible that by arguing that people might vote for the same party in center and state government, it's likely that we're sort of challenging the intelligence of the Indian voter. All right. Then there are other arguments like it ignores diversity, it would dissipate federalism. All right. So all these arguments you can provide against. All right. Now the stability argument that I talked about, right? That simultaneous elections would provide for stability of government, right? Now that argument could work by something called the Shekhawat solution. All right. Now you don't need to write that. What you will say is that the former Vice President Bhairav Singh Shekhawat offered a way out of the stability conundrum. He said that we should employ something called the constructive no confidence motion. Now, what is a constructive no confidence motion? Now, what happens is whenever a party is trying to pass a no confidence motion, the government falls in the state and now you have to conduct elections again, right? So the chances of re-elections are always very high if the party in power does not have enough sufficient numbers. Now, what Bhairav Singh Shekhawat said, what Bhairav Singh Shekhawat made a very forceful argument about is that what we should do is that the parties who are coming together to bring down the government should first prove that they have a majority. right? So that the alternative government is already in power when the first government falls. So what would happen is that the chances of governments falling midway are very low, right? And incidentally, what would happen is that we will be able to organize simultaneous elections more effectively. All right. So I hope you are sort of clear on one nation, one election question. If it turns up, see, the problem here is that there is not much scope for getting more marks than your peers in your mains exam, right? So that's why I've put in the Shekhawat solution here to sort of give you that edge, right? So let's move on to the next point. What's happened is that the northeastern media, the media in the northeastern part of the country is talking about sixth schedule a lot, right? And this commotion has given us an opportunity to sort of discuss the sixth schedule. Now, what is the commotion about? There are we are going to try and understand that. And before that, let's see what sixth schedule is, right? Now, there are more than 10 crore tribal people in the country, right? Most of them live in areas outside of the northeast, right? From the central India, North India, Western India, Southern India, right? And there are some tribal areas living in tribal people living in tribal areas, right? There are most of the tribals in the country are living in areas dominated by other by regular people, right? By people who are not tribals. But there are tribals living in tribal areas, right? In the northeast. So for tribal people living in most part of the country outside of the northeast, we have a fifth schedule, right? And remember that this fifth schedule and sixth schedule were passed by the constituent assemblies themselves, right? The assembly themselves decided that there is going to be a fifth schedule and a sixth schedule, a special provision for tribals, all right? So for tribal people living in the country outside of the northeast, we have the fifth schedule. And for a smaller percentage of those 10 crore people living in the northeastern states, 4 northeastern states, we have the sixth schedule. All right. So if you understand this, for example, you could refer to the notes here. The sixth schedule covers the areas that are settled in the northeastern states bordering China and Myanmar. All right. Now, why is this in news? Why is this schedule in news, right? It's in news because a BJP national spokesperson in Mizoram said that the center is committed to amending the sixth schedule by 125th constitutional amendment. Now, so we need to know what is the 25th constitutional amendment. But before we can understand what is the 125th constitutional amendment, we need to understand a few more things about the sixth schedule, all right? And most of this you will cover in your polity class, but quickly let's revise, right? Let's revise the provisions of the sixth schedule, all right? It consists of provisions for 4 states, right? Assam, Meghalaya, Tripura, and Mizoram, all right? And this sixth schedule comes from Article 244 of the Indian Constitution, right? It was passed by the Constituent Assembly in 1949 for providing safeguards to the rights of tribal population through the formation of, this is important, autonomous district councils, right? ADCs, right? So what the governor has the power to delimit or to have an area of people of area inhabited by tribal people and constitute an autonomous district council, a governing structure, right? And many of these ADCs could come together and we could have a regional governance council also, right? So it's a body with relative autonomy from the state government, right? They decide their own issues, right? So that's the idea behind an ADC, all right? The governors of these states are the authorities that are empowered to recognize boundaries of tribal areas, right? Along with this ADCs, as I told you, there is scope for regional councils also, which could be incorporated as autonomous regions, as the Bodoland Tribal Council is. Right, and let's move on. So these are some provisions that you need to just go through. Broadly, what I will tell you is that there are 30 members in an autonomous district council. Some of them are elected. There is proper representation of different tribal groups. In short, some of them are nominated by the governor, right? And all of them remain in power for 5 years. Now, for a regional council such as the Bodoland Territorial Council, the upper limit is 40 and 35 are reserved for scheduled tribes and non-tribal communities, and 5 are reserved for the rest in that for the rest. All right. So, and there are some nominated members also. This, which is not very important. All you need to do, not need to have, is a vague idea, is a broad idea of how these ADCs or regional councils are governed. Right now. Their powers extend to sort of judicial matters more than executive matters, right? So the disputes, that their intertribal disputes, shall be settled in their own ancestral traditions, right? That is why the powers of the High Court are not applicable, or applicable with some reservations, with some conditions, right, to these areas. The governor has the power to decide what powers of the High Court are applicable and what powers of the High Court are not applicable. Besides the judicial matters, there are areas like land, forest, fisheries, social security, entertainment, public health, which is very important, which are their domain, right? So what is the problem, right? What exactly is the problem? But to understand what exactly the problem is, you need to understand the fact that in elections in Mizoram, what happened was that the local people there said that when the 15th Finance Commission was conducting investigations, it did not grant us enough financial powers. Right? We have so many decisions to make, we have so many developmental works to do, and there are very limited financial powers that we have, right? And that is why there is in January 2019, the cabinet approved amendment to Article 280, which is the Finance Commission, and the 6th schedule to increase what? Autonomy, financial resources, and powers of the autonomous district councils in Assam, Meghalaya, Mizoram, and Tripura. All right, what would this do? This would allow the autonomous councils to sort of tell the state governments not to interfere with their functioning so much. All right, and if you look at the map here, you can see these autonomous councils. There is Gorkhaland Autonomous Council, there is in Meghalaya we have Garo, Khasi, Jaintia, and this here is the action, where is the action is, right? Mizoram. So you have Chakma, Lai, and Mara ADC. This Mara ADC is where the BJP government is in power. All right, and this is where the BJP representatives has been saying for a very long time that the state government is influencing, is interfering into their autonomous district council too much, and that is why the central government is now proposing, now this amendment is now being studied by a parliamentary panel, and it is very likely that this amendment, this constitutional amendment, might just go through the parliament. All right, so if you understand this, I think you are sorted. Right, you're mostly sorted. Just another word on the takeaway. What you need to write is that ADCs have ensured that the tribals have an identity, a sense of identity, and to restore, and they have restored a sense of identity. And once their identity is associated with the ADCs should be strengthened and given financial resources to do developmental work in that area. All right. So this is all that you need to know about the autonomous district councils. Now you understand what the 125th amendment seeks to do, and you sort of have an idea of what the ADCs do. All right, now you must have heard a lot about the conversion laws, right? You must have heard the fact that marriage and religious conversion are being put together in the same sentence in a lot of the news that you're hearing. Let's get a grip on what the Uttar Pradesh law tries to do. All right, so the governor of Uttar Pradesh has recently promulgated an ordinance for something called unlawful conversion. All right, and that's the important part, right? So what is the argument of the Uttar Pradesh government? That they're not against government, they're not against religious conversion, but we are worried that most of these conversions happen under duress or coercion. All right, so what are they against? They're against unlawful conversion from one religion to another. All right, and it specially criminalizes, all right, it specially criminalizes conversion solely for the purpose of marriage. All right, so the political narrative here is love jihad, but there is an argument to be made that they don't want forcible conversions only for marriage. All right, so the ordinance makes religious conversion for marriage a non-bailable offense, so it's an excessive criminalization. All right, and the onus, the burden of proof is on the person against whom there is a charge, against the defendant, to prove that he did not convert only for marriage, right? There's a notice period involved, and if there is a woman who is converted, that marriage is declared null and void. There are fines involved, and if the woman is a minor or a member of the scheduled caste or scheduled tribe community, then there is a jail sentence and a fine, right? So it's a stringent law, right? Now, what has the Supreme Court said on conversions in marriage, right? It's a question of liberty, right? So the pivot of your answer, because there is a state agency that has made this claim, so you need to sort of be understanding of their argument also, and you need to sort of provide both sides of the coin, right? So what are they saying? They don't want forcible conversions only for the purpose of marriage. All right, but what has the Supreme Court already said? The Supreme Court has already made it very clear that faith, religion, state, or the courts have no jurisdiction over an adult's absolute right to choose a life partner. This is what you need to write. Or the Supreme Court has already made it clear, and there are two judgments that you need to specifically refer to. One is the Hadia judgment in 2017, where the Supreme Court said that not only marriage, but ideas of dress, food, ideas and ideologies of love and partnership are within the central aspects of identity, right? Whom you decide to marry is a question of your personal identity, and whatever you decide is beyond judicial constraints. All right, and then in K. Puttuswamy, which is the right to privacy judgment in 2017. Now, K. Puttuswamy did not directly talk about marriage issues, but it did have references and let's say strong references to the fact that autonomy of the individual is the ability to make vital decisions, and they will not infringe upon the autonomy of the individual, right? They said this constitution is about the autonomy of the individual, that he can take decisions, and if two individuals have autonomously decided that they are going to marry, then there is not much scope for judicial intervention. All right, so in your conclusion, what you're going to write? You're going to write about the fact that there needs to be a balance between freedoms and malified conversions, right? The Supreme Court itself has said that forcible conversion is not a right? So if there needs to be a balance that needs to be struck between malified forcible conversions and the right to marry whomever you want. All right, that's going to be the pivot of your answer. Now, the last two slides are not exactly to do with mains, but they could help out. How would they help out in mains? Is that you could use these as examples in your questions on governance, right? And they could be asked in prelims also. All right, so let's look at what Pragati is, right? And I would not have picked up Pragati if it was just another app the government was dealing with. The reason I've picked it up is because 12.5 lakh crore worth of projects have been reviewed on this platform, right? It's Pragati, it stands for Proactive Governance and Timely Implementation, and Prime Minister chaired 33rd Pragati meeting, right? So it's an active instrument of review for government projects by state governments or central governments, right? And the Prime Minister, it's located inside the Prime Minister's office only, and so the most powerful person in our democratic system is using this platform over and over again to ensure that projects are being run on time, and that is why you need to sort of know what Pragati is. It's a multi-purpose and multimodal platform, and what it tries to do is that it tries to address common man's grievances and also monitor and review programs and projects of state as well as the government. All right, and this is important that it has reviewed projects worth 12.5 lakh crores. All right, that number could be easily reached, but still you need to it's still important, right? If the most powerful man in the country is using a particular platform to ensure that governance is smooth, it becomes important for your prelims as well as mains. All right, the others and the last such topic is this pro bono legal service app by the name of Nyaya Bandhu. All right, now what the government has done is that it has now made this Nyaya Bandhu app available on the Umang app. Now, what is the Umang app? The Umang app is a service delivery app that the state governments and central government have made a common platform for service delivery, right? Now, what is the idea of Nyaya Bandhu? The idea of Nyaya Bandhu is to implement the DPSP of making legal aid available to everyone. So what you can do is sort of get onto the app and register and sort of can get legal advice from another legal professional, right? From a legal professional, right? So, and all these services on Nyaya Bandhu are pro bono, therefore free, right? So lawyers who are willing to offer free legal services register themselves on the app. It is aimed at benefiting, it is already benefiting 73,000 paralegal volunteers, right? It is benefiting them, but it's also benefiting those who are seeking help, right? It comes under the National Legal Services Authority and state legal services authorities in the country, right? So this also, if there is a question in your mains about judicial decisions, judicial services, please write this Nyaya Bandhu app. All right, now I really hope you're reading your newspapers properly, and please, whenever you come across an important opinion page or something that's striking as an issue in your GS syllabus, do not just read it, spare a minute and form an answer in your head. All right, and possibly recite it to someone, right? Possibly discuss it with someone. What it will do is that it will embed the answer in your memory, commit it to memory. So whenever there's a question in GS, in mains, you could quickly just get to it. All right, that's the idea behind trying to form answers in your heads. All right, so thank you so much for listening. Thank you so much for paying attention. I really wish you all the luck, and keep studying. Study well. Bye bye.